The courtroom went quiet when Imani. "No, wait, let me start with the room." The room smelled like old paper and ambition, the way every federal courtroom in Chicago smells when something important is about to happen. And most of the people in it haven't figured that out yet. Judge Harold Fenwick was already irritated. You could tell by the way he adjusted his glasses twice before 9 a.m. He had been on the bench for 26 years. He had seen young attorneys walk in here with confidence they hadn't earned, and he had watched that confidence get dismantled, piece by piece, in front of a full gallery. It was not his favorite thing to witness, but it happened often enough that he had stopped being surprised by it. The opposing counsel, senior partner Reginald Ashford of Ashford & Cole, sat at the plaintiff's table, arranging his notes with the quiet precision of a man who had already won. His suit was charcoal, his cufflinks were silver. His client, Harman Biotech, was worth $4.7 billion, and he had represented them for 11 years without losing a case. He did not look up when the defense table filled. What he did do, and the court reporter noticed it, and the bailiff noticed it, and two of the jurors who had already taken their seats noticed it, was smile. Just slightly. Just at the corner of his mouth. The kind of smile a man makes when he sees exactly what he expected to see and finds it amusing. What he saw was Zinddi Okafor. She was 29 years old. She was the only black woman in the room who wasn't a spectator. She was carrying a leather portfolio that had a small scratch near the bottom clasp, the kind of scratch you get when you've used something so many times it starts showing its history. She set it on the defense table without looking at Ashford. She did not acknowledge his smile. She pulled out her chair, sat down, and opened her portfolio to the first page, and she did not look up again for 2 full minutes. Her client, Dr. Okafor, no relation, though people always asked, sat beside her. He was 63 years old. He had spent 31 of those years developing a cardiovascular monitoring algorithm that Harman Biotech had allegedly stolen, repackaged, and turned into a device now used in hospitals across 14 states. He had filed the lawsuit himself with his own savings before any law firm would touch it. He had walked into Zinddi's office 8 months ago with a banker's box of documentation and a look on his face that she recognized immediately. She had seen that look on her father's face, on her uncle's face, on the faces of men who had built something real and watched someone else take credit for it, and understood, finally, that the system designed to protect them was not designed with them in mind. She had taken the case. Her managing partner, a man named Gerald Koss, had called her into his office the next morning. Zinddi. He had said her name the way people say names they've never been sure how to pronounce, landing on it too hard. "Sit down." She sat. "I've looked at the Okafor file." He folded his hands on his desk. "This is a David and Goliath situation, and I don't mean that in an inspiring way. I mean it in the way where David loses and we lose our retainer and our reputation along with him." "The documentation is solid," she said. "Ashford has tried 17 IP cases in federal court. He's won 16. I know, the one he lost." The plaintiff had 3 former Harman employees willing to testify, and a paper trail that started in 1987. He paused. "What do you have?" She had looked at him evenly. "I have what I need." He had leaned back in his chair and looked at her the way men look at something they've already written off. Not with cruelty. With something worse than cruelty. With patience. The patience of someone who is very sure they are right and is simply waiting for you to understand that. "I'll let you run with it," he said, which was his way of saying, "When this falls apart, it won't fall apart on my desk." That had been 6 months ago. The case had taken everything she had. She had slept 4 hours a night for 3 weeks running. She had eaten meals over her keyboard and missed her niece's birthday and canceled a trip she had been planning for 2 years. She had read every patent filing Harman Biotech had submitted between 2014 and 2022. She had cross-referenced their device specifications against Dr. Okafor's original algorithm documentation. She had found something that Ashford's team, in their confidence, had not thought to look for. She had not told anyone what it was. Not her paralegal, not her partner, not Dr. Okafor, except in the broadest terms. "Trust me, I have it. We will be fine." He had looked at her across the table in her small office, her office that did not have a window, her office that was on the 4th floor, while the partners were on the 7th, and he had said, very quietly, "Young lady, I believe you." She had not needed him to say it, but she had been glad he did. The morning session opened with Ashford's opening statement, which was polished and assured and 40 minutes long. He walked the jury through Harmon Biotech's development timeline. With the ease of a man telling a story he has told many times, he showed slides. He quoted the company's chief engineer. He described their research process in a way that was technically accurate and emotionally compelling, and, Zinddi knew, strategically incomplete. She watched the jury while he spoke. 9 women, 3 men. 4 of them were nodding. 1 was taking notes. 2 were watching Ashford the way people watch someone they find automatically trustworthy. Not because he had earned it, but because he was standing where trustworthy people usually stand. When it was her turn, she stood up. She did not use slides. She did not have a remote clicker. She walked to the center of the room, and she stood there for a moment before she said anything, and in that moment, something happened in the room that she could feel, but not name. A settling, an attention. In 2016, she said, a man named Dr. Okafor sat at a desk in a 1-bedroom apartment in Evanston, Illinois, and wrote a line of code that would eventually save lives. He didn't have a lab. He didn't have a grant. He had a laptop and a yellow legal pad and 30 years of expertise in cardiovascular medicine, and a question that nobody else had thought to ask. She paused. The question was, what if we could know a cardiac event was coming 48 hours before it arrived? She let that sit. Harmon Biotech will tell you they developed that answer independently. They will show you timelines and engineering notes, and the names of their very impressive team. What they will not show you, what they cannot show you, is a single piece of documentation that predates July 14, 2017. Ashford shifted in his seat. She clocked it without looking at him. Because July 14, 2017 is the day Dr. Okafor attended a conference in Boston. It is the day he presented a preliminary version of his algorithm to a room of 200 researchers. It is also the day that 2 employees of Harmon Biotech were in that room. She walked back to her table. She picked up a single sheet of paper. We will show you the conference registration records. We will show you the badge check-in log. We will show you exactly who was sitting in that room when Okafor showed his work to the world for the first time. And we will show you that 8 months later, Harmon Biotech filed a patent for a device built on the same foundational logic, with none of his name on it. She set the paper down. This is not a complicated case, she said. It is only made to seem complicated, because complicated is easier to dismiss. We're going to uncomplicate it. Together. She sat down. In the gallery, someone exhaled. The first week of trial was, by most measures, Ashford's. He was experienced and thorough. His witnesses were polished. His expert, a professor from MIT, with 17 publications, and a manner that was both authoritative and likable, spent 2 days explaining why Harmon Biotech's algorithm and Dr. Okafor's algorithm were, in his professional opinion, conceptually analogous but technically distinct. Conceptually analogous but technically distinct. Zinddi wrote those 4 words on her legal pad and underlined them twice. During the lunch recess on the 3rd day, Ashford stopped her in the corridor outside the courtroom. He did not do it in a way that was obviously aggressive. He did it the way men who are very good at what they do the things. Smoothly, with the texture of courtesy. "Counselor Okafor," he said. He had a coffee in one hand. "You're doing well in there." She looked at him. For a case like this, he took a sip. It's a hard position to argue. The burden of proof is steep. Juries find IP law confusing. It's easy to lose them. A brief pause. There's no shame in a structured settlement. For your client's sake. She smiled at him. It was a real smile which sometimes surprised people. "Thank you for the concern," she said. "I've been doing this a long time," he said. "I know," she said. 17 federal IP cases. He hadn't expected that. She could see it in the half-second delay before he recovered. 16 wins. 16, she agreed. "I've read all of them." She picked up her bag from the bench behind her. "Have a good lunch, Mr. Ashford." She walked away without waiting to see his expression. The turn came on the morning of day 6. Zinddi called Dr. Lenora Baptiste as a witness. Baptiste was a computer scientist at Northwestern, a small woman in her 50s with silver-streaked hair and a habit of looking at questions from slightly sideways as if she was inspecting them before answering. She had spent 4 months reviewing both algorithms at Zinddi's request. She had not been paid. She had agreed to the work. She told Zinddi in their first meeting because she had read about the case in a journal and found the underlying technical question interesting. Zinddi liked her immediately. On the stand, Baptiste was precise. She walked through the structural comparison of the two algorithms with the careful specificity of someone who understood that the jury did not share her technical background and did not resent them for it. She used analogies. She used diagrams, simple ones, that Zinddi had prepared with her. She explained, in language that was clear without being condescending, why conceptually analogous and technically identical in foundational architecture were not the same statement. Ashford's objections came quickly. Judge Fenwick sustained 2 of them, overruled 4. Then Zinddi asked the question she had been building toward. "Dr. Baptiste, in your review of Harman Biotech's internal development documentation, the files produced in discovery, did you find any evidence of the 48-hour predictive modeling framework prior to July 2017? Baptiste looked at the jury. "No," she said, "I did not." "Did you find evidence of that framework in Dr. Okafor's 2016 documentation?" "Yes, extensively." "In your expert opinion, is the 48-hour predictive framework in the Harman device derived from Dr. Okafor's original work?" Ashford was on his feet. "Objection. Calls for speculation. It calls for expert opinion," Zinddi said, still looking at the jury, "which is precisely what Dr. Baptiste is here to provide." Judge Fenwick looked at Ashford over his glasses. Overruled. "The witness may answer." Baptiste folded her hands on the railing. "In my expert opinion, yes. The 48-hour predictive framework present in Harman's Cardio Sentinel device is not independently derived. It is structurally and logically indistinguishable from the framework Dr. Okafor documented in 2016. The room did not erupt. Courtrooms do not erupt. Not really, not the way films suggest. What happened was quieter than that. A stillness. The kind that follows something that cannot be unsaid. 2 of the jurors who had been nodding during Ashford's opening statement stopped looking at Ashford. They looked at Zinddi. Ashford's cross-examination of Baptiste lasted 90 minutes. He was good. He was very good, and there were moments where Zinddi's jaw tightened, where she wrote notes fast on her legal pad and drew lines under things. He found gaps in Baptiste's language. He pressed on probability versus certainty. He made the jury feel for a few minutes the weight of doubt, but he could not unring the bell, because Zinddi had one more thing. She had saved it. She had known from the first week of discovery that it existed, and she had said nothing, filed nothing that would telegraph its importance. She had listed it in the exhibit index as item 47C, which is the kind of label that does not invite attention. It was an email, sent on August 3, 2017, from a Harman Biotech senior engineer named Paul Greer to the company's VP of Product Development. The subject line was, "Boston Framework." The body of the email was 11 sentences long. It referenced by name and date the conference where Dr. Okafor had presented. It described his proprietary predictive model as, and these were Greer's words, "the missing piece we've been looking for." It ended with the line, "We need to move fast before he files anything." We need to move fast before he files anything. When Zinddi read that email into the record on the morning of day 7, the room was so quiet she could hear Judge Fenwick's pen tap once against his notepad and then stop. Ashford sat very still. He was a man who had built a career on composure, and his composure held, but Zinddi had been watching him for 7 days, and she saw what the jury did not. The single moment, half a second at most, where his expression did something it hadn't done since the trial began. It changed. The jury deliberated for 4 hours. Zinddi sat in a conference room down the hall with Dr. Okafor, who was drinking terrible courthouse coffee and not saying much. She had a habit, when she was waiting, of counting things. Her grandmother had taught her that, when she was small and anxious, and couldn't sit still, count the ceiling tiles, baby. Count the floor squares. Count anything. It gives your brain something to hold on to so it doesn't run away. She counted the chairs around the conference table. 12. She counted the windows. 2. She counted the number of times she had almost walked away from this case. 3. Once when Koss implied she was out of her depth. Once when Ashford's team filed a motion that, for 2 days, looked like it might get the whole suit dismissed. Once at 2 in the morning in her apartment, alone with the documents and a cold cup of tea, when she had simply sat with her head in her hands and felt for a few minutes the full weight of what she was doing and why and whether it was going to matter. She had not walked away. She had put the mug in the sink. She had gone back to the table. She had found the email. The bailiff knocked at 3:47 p.m. The verdict was read by a woman named Juror Number 4, who had taken notes the entire trial and looked, throughout, like someone who took things seriously and expected others to do the same. Her voice was steady. Willful infringement. Damages awarded. The number was not the largest number that had ever come out of a federal courtroom. But it was enough. It was more than enough. It was enough to give Dr. Okafor his name back on the thing he had built. He was very quiet when the verdict was read. He did not cry. He put one hand flat on the defense table and pressed down, as if he needed to confirm that the table was real, that he was in the room, that this was happening in the actual world, and not in some version of it he had stopped letting himself believe in. Zinddi sat beside him and let the room do what rooms do when something like this happens. Let the gallery murmur. Let the reporters write. Let Ashford's team collect their papers with the particular efficiency of people who need to be somewhere else. After a moment, Dr. Okafor turned to her. He said, simply, "Thank you." She nodded. She had learned, somewhere in the last 8 months, that some things don't need to be expanded on, that the right response to thank you, when it is said the way he said it, is not a speech. It is presence. It is having been the person who stayed. In the corridor outside, a reporter from the Tribune caught up with her before she reached the elevator. "Counselor Okafor, can you speak to the significance of the verdict?" She thought about Gerald Koss, who had let her run with it. She thought about Ashford in the corridor, with his coffee and his 16 wins and his patience. She thought about 2 a.m. and the mug in the sink and the moment she had decided to go back to the table. "It's significant," she said, "because it's true." The reporter waited for more. She pressed the elevator button. "The truth was always there," she said. "Somebody just had to stay in the room long enough to say it out loud." The elevator doors opened. She stepped in. She did not look back. Gerald Koss called her that evening. She let it go to voicemail. He said, among other things, that she had done exceptional work, that he had always believed in the case, and that they should discuss her partnership track at her earliest convenience. She listened to the message once. She set her phone face down on the kitchen counter. She made herself a cup of tea and sat at her own kitchen table. Not the office table, not the courthouse conference room table, her table, in her apartment, with the window that looked out over the street, and she sat there for a while without counting anything. Outside, Chicago went about its business. Someone honked. A siren started and faded. 2 people were arguing on the sidewalk about something small enough that it would probably be resolved by morning. Zinddi Okafor, 29 years old, attorney, daughter, granddaughter of a woman who had told her once that counting things when you're scared is how you keep your brain from running away, sat in her kitchen and drank her tea, and felt for the first time in 8 months the specific quiet of a thing that is finished and was worth finishing. Some rooms you fight your way into. Some verdicts you build one document at a time, in the dark when nobody is watching and nobody yet believes. The world will tell you, many times and in many voices, that the room is not for you. It will tell you this, directly and indirectly, and with great patience and occasionally with a coffee cup in hand. But the room was always for you. It was waiting. It just needed someone willing to stay.